All right, good afternoon, everyone, and welcome to the Maryland State Commission on Criminal Sentencing Policies, Sentencing Guidelines, and MAGS 101 training for states' attorneys, parole and probation investigators, and defense attorneys. My name is Catherine Pembroke. I'm the Administrative and Training Coordinator for the MSCCSP. Now, the sentencing guidelines play a significant role in supporting fair and proportional sentencing practice. Accordingly, your participation in this training and staying up to date on the sentencing guidelines, it's really important because it helps to promote the consistent application of the guidelines. So I do want to note that today's webinar is being recorded and this video will be made available on our training website. So let's review the agenda for today's training. Today, we're going to be covering the basics of sentencing guidelines calculation and Maryland automated guideline system functionality. So we're going to begin by reviewing instructions and frequently asked questions that will cover a variety of topics to include sentencing guidelines eligibility. Then we'll look at some specific areas of guidelines calculation, talk about some recent updates, and then we're going to wrap up with a demonstration in MAGS. And it's going to include a specific emphasis on some newer features that have been deployed. Now, even though I have already compiled some frequently asked questions that we're going to review, if we get to a topic that may be relevant to a question you have, we certainly encourage you to submit any questions through our chat box. My colleague Sarah Bowles is here with me today, and she will be able to respond to any questions in real time throughout the chat box. And then at the end of the presentation, we can take any outstanding questions at that point as well. Lastly, you should be seeing a PDF of today's presentation coming through within the next few minutes, and you can feel free to download that PDF for future reference. So let's begin with a quick review here. What is the purpose of sentencing guidelines? Now, the sentencing guidelines are a mechanism to encourage proportional sentences. The primary goal of the guidelines is to promote consistent, fair, and equitable sentencing practice, whereby offenders who are adjudicated of similar offenses with similar criminal histories, they're treated and sentenced alike. Now, the Maryland sentencing guidelines were designed to systematically account for the most common variations in offenders and their offenses. They help to achieve proportional sentencing by identifying and assigning weights to core objective factors for consideration by judges in making sentencing decisions. They really help to provide a framework to allow judges to consistently assign the same value or score as their colleagues around the state for each of these legitimate legal factors. Now, the guidelines provide a baseline for judges by offering a recommended range based on the average sentence for a typical case. And finally, the guidelines also help to improve sentencing transparency, as they're a matter of public record, and the data collected via the sentencing guidelines worksheet are publicly accessible. Now let's talk a little bit about the purpose of the guidelines worksheet itself. It serves two main purposes. The first purpose of the worksheet is to inform the judge of the guidelines prior to sentencing. So Criminal Procedure Article 6-216 indicates that the court shall consider the guidelines at sentencing. And in order to do so, a sentencing guidelines worksheet must be prepared. The second purpose of the worksheet is to provide data so that the commission can make informed decisions about sentencing policy. Criminal Procedure Article 6-210 requires that the Commission collect sentencing guidelines worksheets, automate the information, and monitor sentencing practice. This is why it's especially important that we're getting as many guidelines worksheets as possible so that that data can really help inform the Commission and help them make informed decisions about sentencing policy. So to get started, let's talk a little bit about guidelines eligibility and look at a common question that we receive here. Now, do Maryland's sentencing guidelines apply to misdemeanors? The answer here is yes. The sentencing guidelines apply to guidelines eligible misdemeanors and felonies that are prosecuted in a circuit court. Now, over the most recent years, we've gotten more and more questions about this, with many practitioners thinking that the guidelines solely apply to felonies that are prosecuted in the circuit court, and that's not true. They also apply to guidelines eligible misdemeanors. So let's just take a look at the scope of the sentencing guidelines in greater detail here. So as I just mentioned, the sentencing guidelines apply to criminal cases that are prosecuted in a circuit court. Now, looking on the left-hand side here, these are sentencing matters that require a guidelines worksheet. We refer to these as guidelines eligible sentencings. So these include circuit court original sentencings, jury trial prayers and appeals from the district court, but only when a pre-sentence investigation is ordered, cases adjudicated via probation before judgments. And just to note, this does include the new type of PBJ pursuant to Criminal Procedure Article 6-220, subsection C. And then in addition to original sentencings, we also collect worksheets for reconsiderations, modifications, and three-judge panel reviews, provided that the sentencing event involves a crime of violence and there was an adjustment made to the original active sentence as a result of the recent reconsideration, modification, or review. Now, on the right-hand side here, these are matters that you'll also see handled in the circuit court, but they are excluded from guidelines coverage. So that includes jury trial prayers and appeals with no PSI, offenses that carry no possibility of incarceration, violations of local laws and municipal ordinances, probation violation hearings, criminal non-support, desertion and contempt cases, juvenile court adjudications, and then finally, the guidelines do not apply to district court sentencings. Now, I just want to point out that we have worked with JIS to establish a guidelines eligibility case indicator. So if we look at this screenshot here, it's a criminal docket for the Circuit Court for Anne Arundel County, and you can see that all of the upcoming guidelines eligible cases are marked with this MAGS yes indicator. That's how we know that it's guidelines eligible, meaning that it will ultimately require a guidelines worksheet to be initiated and submitted through the MAGS system. So I did just want to point out that this case indicator exists. If you think it would be a helpful resource to look to, just so you know which upcoming cases will in fact require a guidelines worksheet, I would encourage you to check out the case indicator. All right, so here's another question regarding guidelines eligibility in general here. Now, the question may be, why can't I locate an offense in the guidelines offense table? So maybe you're in MAGS, you're adding offenses, you're looking for a particular offense, and you're having trouble finding it in our guidelines offense table. And one of the reasons could be that it's not a guidelines eligible offense. So we often get guidelines eligibility questions regarding a couple of offenses in particular. Now, as I just mentioned, violations of local laws and municipal ordinances are not guidelines eligible. So I often get questions about this violation of Baltimore City Code, which involves the discharging of a firearm. And while it does carry the possibility of incarceration, because it's a violation of Baltimore City Code, it's not considered a guidelines eligible offense. So even if it were being sentenced with other guidelines eligible offenses, it wouldn't be reflected on the guidelines worksheet. Now, Code of Maryland regulation violations are also generally not guidelines eligible, and they can cause some confusion because oftentimes they do carry the possibility of incarceration. Now, I do want to note it's possible there may be an exception if the penalty for a COMAR violation is outlined in state statute as opposed to COMAR itself. But again, generally COMAR violations are not guidelines eligible. And if there's ever a question about its eligibility, you can always feel free to contact us and we can confirm. Lastly, I did just want to note that effective October 1 of 2025, reckless driving now carries the possibility of incarceration. So therefore, it has become a guidelines eligible offense. So for any cases sentenced on or after October 1 of 2025, if it contains reckless driving, it should be reflected on the guidelines worksheet. And lastly, I do just want to note that some of the more infrequent offenses that have a maximum penalty of less than 1 year, they may not be included in the guidelines offense table, though we do make every effort to update it and include them when those offenses are brought to our attention. So that could be another reason why you're having trouble locating a particular offense in the guidelines offense table, but you can always feel free to contact us and we can confirm if that's the case. All right, so let's talk about the guidelines themselves. Now, Maryland sentencing guidelines are scored on two key factors, that being the prior record and the seriousness of the offense. And in the Maryland system, an offender score is calculated to account for an offender's prior criminal record. The offender score is a summary scale ranging from 0 to 9, which measures an offender's criminal history, accounting for 4 factors, that being the relationship to the criminal justice system when the instant offense occurred, juvenile delinquency, prior adult criminal record, and prior adult parole and/or probation violations. The second component of the sentencing guidelines is the offense seriousness, represented in Maryland by the offense score. Now, for property and drug offenses, the offense ranking is based solely on the seriousness of the offense. But for person offenses, so those typically involving victims as well as weapon-related offenses, the offense score is calculated by considering three additional factors, that being victim injury, weapon presence, and special victim vulnerability. So let's start breaking down these components here. We're going to start with the four components that make up the offender score, essentially an offender's prior criminal record here. So we're going to begin with a common question we receive regarding the scoring of Part A, and then we're going to review the criteria here. Now, does pretrial supervision constitute criminal justice system involvement for the purposes of scoring Part A, that being the relationship to the criminal justice system when the incident offense occurred? So the answer here is no. So let's take a look at why that is. Now, 1 point should be scored for Part A, that being relationship to the criminal justice system when the incident offense occurred, if the offender was in the criminal justice system as a result of an adjudication as an adult at the time the offense was committed. Now, generally, pretrial supervision wouldn't constitute criminal justice system involvement because they often haven't been adjudicated while they're on pretrial supervision. However, if the defendant was on pretrial supervision, adjudicated of the offense, and remained on pretrial supervision pending sentencing, if that instant offense occurred post-adjudication and prior to sentencing, then it would constitute criminal justice system involvement. But again, generally, pretrial supervision does not meet that criteria. All right, let's look at another common question regarding the scoring of Part A here. Now, does juvenile probation constitute criminal justice system involvement for the purposes of scoring Part A? So the answer here is no. So with the exception of the juvenile delinquency component, the other components of the offender score refer only to the defendant's adult involvement in the criminal justice system. So this is why a point would not be scored for Part A if the defendant was on juvenile probation. All right, one last question here related to Part A. Does the sex offender registry constitute criminal justice system involvement for the purposes of scoring Part A? So the answer here is no. So at the Commission September 17th, 2019 business meeting, this topic was discussed and there was a majority vote against including sex offender registration in Part A's definition of criminal justice supervision involvement. Therefore, if the defender was on the sex offender registry as a result of an adjudication at the time the instant offense occurred, as long as there was no other form of supervision taking place, meaning they were off parole, probation, etc., 1 point would not be scored solely for the defendant being on the sex offender registry. So just something to keep in mind. Okay, moving on to Part B here, that being juvenile delinquency. So 0 points are scored if the offender is 23 or older by the date of the most recent instant offense, or if the offender has 0 findings of a delinquent act within 5 years of the date of the most recent instant offense. 1 point is scored if the offender is under 23 and has 1 or 2 findings of a delinquent act within 5 years of the date of the most recent instant offense. And then finally, 2 points are scored if the offender is under 23 and has had 3 or more findings of a delinquent act within 5 years of the date of the most recent instant offense. All right, so moving on to Part C, that being prior adult criminal record, and we're definitely going to spend a good amount of time here because this is probably the most complicated component of the offender score. Now, aside from a few exceptions that we're going to review in a moment, the prior adult criminal record generally includes all adjudications preceding the current sentencing event, whether the offense was committed before, during, or after the instant offense or offenses. So an important question and answer to keep in mind when you're scoring the prior adult criminal record. Now, should adjudications that were expunged from the record or proven by the defense to have been eligible for expungement as a matter of right prior to the date of offense be excluded from the prior record score? So the answer here is yes. Any adjudications that were expunged or are proven by the defense to have been eligible for expungement prior to the date of the offense should be excluded from the prior record score. So a common instance of a prior adjudication becoming eligible, it may involve a prior probation before judgment. Perhaps probation was successfully completed, 3 years has passed, the defendant did not pick up any new charges, and therefore it would technically become eligible for expungement. However, I do want to note that expungement laws have expanded over the years, and certain prior convictions are now eligible for expungement after a specific period of time. So just something to keep in mind when scoring the prior record here. Now, as a reminder, the prior adult criminal record shall also exclude any violations of public local laws, municipal ordinances, criminal contempt, desertion, and non-support offenses, adjudications that are based on acts that are no longer crimes. So, for example, cannabis possession, 2.5 ounces or less is no longer a criminal offense. So if you see a prior possession of cannabis, you're able to determine that it involved 2.5 ounces or less, it would be excluded from the prior record. Non-incarcerable traffic offenses are also excluded. And then finally, military adjudications imposed by an Article 15 proceeding or summary court-martial, and any findings of guilt by a general or special court-martial if the elements of the offense require the defendant's service in a military force are also excluded from the prior record. Okay, since calculating the prior adult criminal record, again, I mentioned is probably the most complicated component, we're going to review the calculation process in further detail here. Now, when calculating prior record, step one is going to be to identify the offense with the highest seriousness category for each prior criminal transaction. So if you have multiple adjudications that stem from the same prior criminal transaction, you're only counting the offense with the highest seriousness category. Step two is then to count the number of offenses in each seriousness category, using only those offenses that you identified in step one. Step three is then to use our criminal record matrix to identify the corresponding prior record level. And we're going to look at a hypothetical prior record in a second here. But before we do, I also want to note that Maryland allows for what we refer to as the criminal record decay factor. Meaning if a defendant has remained free of criminal justice system involvement, meaning they have been off parole, probation, mandatory supervision for 10 years prior to the instant offense, the criminal record should be reduced by one level. So if you initially calculate it to be a moderate, if the defendant's prior record meets the criteria for the decay factor, it would be reduced from a moderate to a minor record level. All right, so let's look at a hypothetical prior record here. Let's say back in October of 2018, we have a defendant who was convicted of a second-degree assault and a resisting arrest. Both are stemming from the same transaction. So you're only counting the most serious offense towards the prior record. And between the two, it's the second-degree assault with the category 5 that you would be counting. Then in 2019, there was a conviction for possession of cannabis, but I was able to determine that it involved 2.5 ounces or less. That's no longer a criminal offense, so it would be excluded from the prior record. Then in 2020, there's a conviction for a first degree assault, which is a category 3. And then in 2022, destruction of property less than 1,000, which is a category 7. Now, out of the three convictions that I'm counting towards the prior record, it's the first degree assault that has the highest seriousness category of 3. So when I look to the record matrix here, I'm going to look to the seriousness category column on the left-hand side, and then the number of adjudications within that seriousness category. So I have one seriousness category 3, meaning I'm going to be referring to the first box here. So I can see that this results in a moderate record level and would jump to a major if combined with 2 or more offenses in categories 4 through 6 or any 6 offenses in general. Now, I only have one other offense, that being the second degree assault, which is a 5, that falls within this category 4 through 6 range, which means it would stay a moderate. But let's say instead of this destruction of property, if I had a second degree assault, so therefore had 2 additional category 5s, it would bump up to a major. So hopefully that helped walking through a hypothetical prior record scenario here. All right, another question to keep in mind regarding prior record score. Now, if a seriousness category changes for an offense, which seriousness category do I use to calculate the prior record? And the answer is the offense seriousness categories in effect at the time of sentencing shall be used to calculate the prior record. However, if it's determined that the guidelines are different than what they would have been if calculated using the sentencing guidelines and offense seriousness categories in effect on the date the offense was committed, the state's attorney or defense counsel can certainly bring it to the attention of the judge as a consideration for departure from the guidelines. But again, you want to be using the seriousness categories in effect at the time of sentencing when calculating and categorizing all prior record offenses. Now, I also want to talk about adjudications out of jurisdiction. I've been getting more questions about them, and actually, a practitioner had asked that this be reviewed during the training. So I want to talk a little bit about adjudications out of jurisdiction. Now, if an offender has an out of jurisdiction adjudication, the adjudicated offense shall be matched as closely as possible to the closest analogous Maryland offense. And when you're trying to find that closest match, you really want to consider the offense itself, the elements of the offense, the maximum penalty, and look at the felony misdemeanor classification. And if it's determined that no Maryland analogous offense exists, the offense should be placed in the lowest seriousness category, that being a 7, and the judge and the other parties shall be notified. So if there's ever a disagreement between the state and the defense as to what may constitute the closest analogous offense, that should be brought to the judge's attention at sentencing, and ultimately the judge can decide. And then finally, wrapping up the last component of the offender score, prior adult parole and/or probation violations. So 1 point is scored here if the offender was ever adjudicated in violation of parole or probation, or was adjudicated of an offense while on parole or probation, unless that adjudication arose from the offense or offenses of the instant sentencing event here. So I just want to note that 1 point would not be given in this category simply because a defendant was currently on parole or probation. They would be getting that point for Part A. This is if they had ever been adjudicated in violation of parole and probation. All right, so that wraps up the offender score. Next, we're going to look at the components of the offense score. So I mentioned earlier, the offense score is calculated for person offenses only. So those typically involving victims as well as weapon-related offenses. Now, the 4 components of the offense score that we're going to look at here are Part A, seriousness category, B, victim injury, C, weapon presence, and D, special victim vulnerability. So beginning here with seriousness category. Now we can see here the seriousness category provides a conversion chart whereby the least serious offenses, so those being the categories 5 through 7, are assigned 1 point. To the most serious offenses, those being category 1s, are assigned 10 points for seriousness category. Also, just want to note that generally, any attempt, conspiracy, or solicitation to commit a given offense, it's generally assigned the same seriousness category as the underlying offense. But with that being said, there are a couple of exceptions that come into play with some of the more serious offenses. So, for example, attempted first-degree murder is a category 2, while first-degree murder is a category 1, and the same is true of attempted rapes. So if you are doing guidelines for one of the more serious offenses, and if it involves an attempt, conspiracy, or solicitation, those offenses are actually listed separately in our offense table. Otherwise, again, more generally, you're selecting the underlying offense and then just selecting the appropriate conspiracy, attempt, or solicitation radio button. And we'll talk about that when we get into the MAGS demonstration a little bit later on here. All right, so moving on to victim injury, which is defined as reasonable proof of injury, which may be physical or psychological, the cause of which is directly linked to the conduct of the defendant in the commission of the offense. So non-permanent injuries are assigned 1 point, permanent injuries or death are assigned 2 points. Now, I do want to say this component of the offense score, it does allow for some discretion. So, for example, our current language pertaining to physical injury, we say that physical injury shall be more than minimal, which is quite vague, but I do want to note that this is a topic the Commission is currently discussing, so it's possible there could be some provisions forthcoming. But again, there is some discretion in scoring victim injury here. Now, With regards to psychological injury, effective January 1 of 2026, the Commission actually expanded the definition of psychological injuries. So let's review the new instructions that have gone into effect here. So as just noted, at our September 9th, 2025 meeting, the Commission voted to expand the definition of psychological injury. And specifically, the expanded definition provides the following. It states that the sentencing guidelines recognize that not all victims have access to psychological counseling or treatment. Victims may not have been provided treatment, and the psychological impact on certain victims, for example, minors, may not manifest until later in life. Proof of psychological injury shall be based on one, confirmed medical diagnosis or psychological counseling or treatment, or two, other forms of reasonable proof. Further noting that rape crisis hotlines, clergy conferences, educational counseling, and other similar services are considered psychological counseling or treatment, and permanent psychological injury shall be based on proof of a substantial impairment likely to be of an extended or continuous duration. So I just want to note here, prior to this expansion going into effect on January 1, there had to be some sort of proof in order to score any psychological injury, whereas now it also allows for other forms of reasonable proof. So that is the main difference in the scoring of psychological injury that went into effect on January 1. All right, moving on to Part C, that being weapon presence. So this is defined as the presence of any article or device that reasonably appears capable of causing injury. So 1 point is scored here for a weapon other than a firearm, such as a knife or a BB gun. 2 points for a firearm or an explosive. And I do want to note that in generally, when calculating the offense score, we do have language in our manual that states the judge may include factors known to the judge outside of the scope of the convicted offense. So, as an example, if you have a defendant that was charged with an armed robbery, but they ended up pleading to robbery, points may still be awarded for firearm or weapon presence. And let's look at another question related to weapon presence here. So, how many weapon presence points are applied when a weapon is feigned? So, the answer here, one. So, essentially, a weapon other than a firearm. Now, a feigned weapon shall be scored 1 point when an individual intentionally creates the false impression that there is an actual weapon present. So, this could include a finger used to simulate a gun, a written note stating that there is a dangerous weapon present, or a verbal statement that there is a dangerous weapon present. All right, I'm wrapping up with Part D, special victim vulnerability. So 1 point is scored here if the victim's younger than 11 or 65 years old or older, or if they have a temporary or permanent physical or mental disability, including an individual who's physically or mentally limited in a material way. So examples of this may include, but are not limited to, instances in when the offender knew or should have known the victim was pregnant, unconscious, asleep, or intoxicated. 1 point would be scored for this category. All right, now let's talk a little bit about overall guidelines calculation, and then we're going to look at a special application that adjusts the overall guidelines range here. So this is a common question that we receive. If the indictment includes multiple offenses that were committed over a period of time, should they be treated as one criminal event or multiple criminal events? And the answer is that it really just depends on the circumstances of the case. But let's just take a look and review the criteria for a single criminal event versus multiple criminal event. Now, for guidelines purposes, we define a single criminal event as one or more crimes committed in the course of the same transaction. And in determining whether they are committed in the course of the same transaction, you should consider whether the crimes are one, committed close in time in an uninterrupted course of conduct, two, occur in the same location, and three, are similar in nature or intertwined. So, for example, whether they share a common scheme or purpose. Whereas multiple criminal events means more than one criminal transaction was committed over a period of time. Now, multiple criminal events being sentenced together, they may have occurred on the same date or different dates. But generally, offenses that occur on different dates are almost always going to be considered separate criminal events. Now, taking that information, let's review what constitute A sentencing event. Now, a sentencing event is defined as a sentencing disposition or hearing for an individual defendant conducted in front of one judge on the same day. Now, even if you have multiple criminal events, which often have unique case numbers, they occurred on different dates, if they are being sentenced by the same judge on the same day, they constitute one sentencing event, meaning that one set of sentencing guidelines should be completed for that sentencing event. And I'm going to touch on this when we get into MAGS. You all are going to be multiple criminal events, single sentencing event experts by the end of this training. But this is very important to keep in mind to ensure proper calculation of the guidelines. Last thing to note that merged or null process offenses should not be reflected on the guidelines worksheet. We'll talk about how to remove those when we get to the MAGS demonstration. Okay, so next I want to talk about a special application, probably the most common special application that can adjust the overall guidelines calculation. So we refer to this as the guidelines victim stacking rule. So here's an example of where the overall range is adjusted due to a case involving multiple victims within a criminal event. So in this type of case, the guidelines range for each individual offense, it's still calculated as normal, but instead of using the highest of the upper and lower guidelines limits, the highest of the lower limit is taken and the upper limits for each offense involving a unique victim are instead added or stacked. Now, I just want to note if you have multiple offenses that relate to the same victim, you're only going to stack the upper limit for the offense with the highest seriousness category. That essentially gives you that highest upper guidelines limit. So looking at this example here, let's say we have an individual who was convicted of 3 counts of second-degree assault, each involving a unique victim. They're all originating out of the same criminal event. Now, the overall range for this event would be adjusted to account for the 3 separate victims. So you can see here we still have an individual guidelines range calculated for each assault second degree. And then instead of in this type of scenario, typically the overall range would be the highest of the lower and the highest of the upper limits. The overall guidelines range is actually enhanced to 2 years to 15 years to reflect the 3 separate victims in the case. So let's review the criteria for applying the multiple victim stacking rule. Now, as a reminder, there must be a criminal event with multiple distinct victims. There cannot be more than one seriousness category 1 or 2 offense. So if you had a case involving multiple first-degree murder convictions, you wouldn't be able to apply the stacking rule. 1 adjudicated offense per distinct victim may be used to calculate the guidelines. So again, if you have multiple offenses relating to the same victim, you're stacking the offense with the highest upper guidelines limit for that victim. And lastly, only the upper limit stack. So let's review a couple of common questions related to the stacking rule here. Now, is the victim stacking rule limited to person offenses? And the answer, no, it's not limited to person offenses. So for example, if you had multiple victims of a theft scheme, you're treating it as one criminal event, you could certainly apply the victim stacking rule in that type of scenario as well. And then lastly, are animals considered victims for the purposes of applying the stacking rule? So the answer here, yes. Effective October 1, 2025, yes. So pursuant to Senate Bill 152, House Bill 89, each animal harmed in violation of Section 10, Subtitle 6 of the Criminal Law article shall be considered a victim when applying the stacking rule. So just to note, this doesn't apply towards hunting and fishing offenses, but if you had, for example, an animal cruelty case, if you had several counts of animal cruelty involving different victims, involving different animals, those animals should be considered victims, and the stacking rule should be applied in that type of scenario. Okay, so that wraps up the review of the basic calculation of the guidelines. And next we're going to get into our MAGS demonstration here. Before we do, I just want to quickly point out our MAGS homepage. We have a bunch of instructional and support materials. If you ever need a refresher, if you have a new colleague who comes on board, I would certainly recommend they check out our MAGS homepage where you can see we have 2 instructional videos, we have some frequently asked questions, and a very thorough MAGS user manual. So really, if you ever have a question about MAGS, definitely check out our homepage here. And you can also feel free to contact us. I'm always happy to answer any questions. Now, before I actually log into the MAGS demonstration, I also wanted to point out our guidelines calculator tool, which is accessible from our homepage. Now, the guidelines calculator tool, it's a standalone tool that can be utilized by anyone to calculate sentencing guidelines. So you don't need a user ID or password to access it. The only caveat is once you utilize the tool, it doesn't save or store the information. So once you close out of your browser, if you wanted to go and like take a look at the worksheet, you'd have to initiate it from scratch once again. But it's a very helpful tool. I know a lot of prosecutors utilize the tool, during plea negotiations just to calculate sample guidelines. Especially helpful tool for defense attorneys as well. So you all can use this to calculate sample guidelines. And I do want to note if we have any defense attorneys who are currently in attendance, I encourage you all to stick around for the MAGS demonstration that we're going to be doing next because the guidelines calculator tool, it essentially mirrors the first few tabs that you see in MAGS. So everything that I'm about to show you in MAGS applies to the guidelines calculator tool as well. So definitely encourage you to stick around. Okay, at this point in time, and just bear with me, I'm going to go ahead and bring up MAGS. Okay, so you should be seeing the MAGS login screen now. So I would imagine everyone in attendance is probably already familiar with their username and password, but if you're ever having issues, please feel free to contact us. I also want to note if there are any defense attorneys in attendance, you all have read-only access to worksheets that are initiated in MAGS. So you definitely have access to MAGS. And we certainly encourage you to log in and view either the state or parole and probation's calculation of the guidelines. And then you could certainly utilize the guidelines calculator tool to calculate your own sample guidelines as well. All right, so after logging in, you're brought to the home screen here, and it's from the home screen where users can either create a new worksheet or you can view, edit, or delete an existing one. Now, it's always good to get in the habit of searching the system to make sure you're not duplicating an already existing case. This is especially true for parole and probation agents because there are times where the state's attorney may go ahead and initiate the guidelines worksheet only for a pre-sentence investigation to eventually be ordered. And we want to avoid duplicating worksheets. Otherwise, it gets very confusing for judges and their designees to know which worksheet to ultimately submit if they're seeing duplicates. So that said, if parole and probation logs in, views or vice versa, views the state's calculation. If they agree with everything, the worksheet really can be left as is. However, if there is any disagreement, we ask that the two parties connect, have that conversation in hopes of clearing up any discrepancies so that ultimately there is only one worksheet in the guideline system. Now, before we go in and walk through initiating a multiple criminal event, single sentencing event scenario, there is a feature that I want to point out, that being the reconsideration, modification, or three-judge review for COV sentences feature. Just based on some conversations I've had with state's attorneys since we've implemented this feature, there are still a good number that don't know that this feature exists. And I want to show you how it works because it's going to save you some time down the line here. So we talked earlier in the training, in addition to original sentences, we also collect worksheets for reconsiderations, modifications, or three-judge reviews if the sentencing event involves a crime of violence and if there was an adjustment made to the original active sentence. Now, prior to this feature existing, by guidelines rule, the guidelines for the upcoming reconsideration should match the original guidelines calculation in the case. So you all were having to go in and initiate a worksheet from scratch for the upcoming reconsideration that essentially matched the guidelines calculation for the original. So this feature now is going to streamline that whole worksheet initiation process for you. And it essentially allows you to copy the original guidelines calculation for the original sentencing event. The only caveat is that the original guidelines worksheet has to have been submitted through MAGS in order to make a copy of it. So let me show you how this feature would work. So let's say you have an upcoming reconsideration that you know is guidelines eligible, and you're going to search the system to see if the original worksheet is in here. So to do so, you simply check that box, and then you're going to search by case number. So I'm going to go ahead and search for my case number here. and click search. So you can see once I do that, I get a return for a John Smith with that same case number. I can see it was sentenced back in 2023. There's a little check mark under the submitted column, and I also just see the word submitted. So I know that this was clearly submitted in MAGS. Now, to make a copy for the upcoming reconsideration, you simply check this little copy icon, and it's going to ask you to confirm that you want to copy it, and you click OK. So it's going to bring you to the offender information tab. Now, scrolling down, you can see that much of the information that populates on offender information, same is true for offender score list of offenses, it pre-populates based on the information that was submitted on the original worksheet. A lot of it's also disabled so that that information remains the same. Now, that said, there are some fields that are going to need to be completed in order for you to move forward. We can see throughout MAGS, the mandatory fields have red asterisks next to them, meaning you have to enter some sort of value in that field before you can move forward. So I would simply just enter my worksheet preparer name and then say I'm with the state's attorney's office. And again, there are some fields that are editable. So for example, you could note if a pre-sentence investigation was ordered, type of representation for the modification, etc. And then you simply click Save this page. And you can see if I quickly go through offender score, that pre-populates as well as the list of offenses based on that information that was submitted on the original guidelines worksheet. So really, the last tab you would have to complete here would be part of the victim information, just as you normally do. And then you're good to go. So I'm going to jump back to the home screen here, but that's how that feature works. And again, if you didn't know it exists, it could really help you out and save you some time in the future. Okay, so next, let's talk once again about multiple criminal event, single sentencing event scenarios here. So I'm going to quickly search the system for, I'm going to filter by Hartford, and then I'm going to search for a Thomas Adams here so we can talk a little bit more about it. Now, we just talked about when you have multiple criminal events, which often have different case numbers, different offense dates. If they are all being sentenced in front of the same judge on the same day, they constitute one sentencing event. And one way to double check that you are correctly initiating a multiple criminal events, single sentencing event scenario in MAGS is once you're done initiating your worksheets, if you were to just search generally by the defendant here, so you can see once I do that, I get a return for two different case numbers, the 1144 and the 1157. Now, if all of these unique case numbers are linked or share the same worksheet ID number, that's how I know that they were initiated properly. Now, let's say you initiated two separate worksheets. So meaning you clicked the add new button for the first case number, went back to the home screen, clicked the add new button for the second case number. So you ended up with two different worksheet IDs here. If these are in fact part of the same sentencing event, that creates two issues. The first and the biggest issue is that if these are not initiated properly, the judge is not going to be presented with a proper overall guidelines range for the sentencing event. The second issue comes into play when the judge or their designee goes to submit worksheets. So they'd be able to submit the first worksheet, no problem. When they go to submit the second, they actually get an error message saying there's already been a worksheet submitted that contains the same SID number, date of birth, and date of sentence. And then they have to contact us. We combine it and send them back a revised worksheet. But again, it's best to eliminate all of those issues prior to sentencing. So it's very important that multiple criminal events, single sentencing event scenarios are initiated properly. And now, some of you may already be aware that we actually implemented a new feature last year that should hopefully prompt you all to correctly initiate multiple criminal event, single sentencing event scenarios. So I'm going to show you really quick what that feature looks like so you know what to do if you encounter it in the future here. So let's just say I'm actually going to initiate a worksheet for the same defendant, Thomas Adams, but maybe I didn't search the system. Maybe I'm not even aware that he has these other two case numbers. So I'm really just clicking add new from scratch here. All right, so I'm brought to the offender information tab where I'm just going to quickly enter some information. And this is just basic demographic information that relate to the defendant here. State identification number. We'll say no PSI. And just to note that race does allow for multi-racial responses. Okay, so then I'm clicking save this page here. So you can see once I do that, I get this duplicate worksheet message. And just bear with me, I know this is a lot of text, but it's important. So this is saying duplicate worksheet, the offender's name, date of birth, jurisdiction are the same as another existing worksheet ID. If there are multiple cases being sentenced as part of the same sentencing event, the worksheets for all of the cases need to be initiated under one worksheet ID to ensure proper calculation of the guidelines. If you are attempting to enter information for a case that is being sentenced on the same day and in front of the same judge as one of the existing cases listed below, please click select next to the case information of the already existing worksheet and then add this instant case information. Now, let's say I am starting to initiate this worksheet. I get this message, but I know for a fact that the case I'm trying to initiate a worksheet for is not being sentenced with these case numbers. It's being sentenced on a different day. It has a different judge. If that's the case, you can just click continue with initiating new worksheet for a new sentencing event, and MAGS will let you go on your way. Now, if you get this alert message and you say, oh, wait a second, my case is being sentenced with these other case numbers. Now, this example is a little easy because these other two case numbers are already linked by this one worksheet ID number. So you could click select next to either worksheet ID since they share it. And it's going to bring you to the proper existing worksheet ID. But if you got this alert and noticed multiple case numbers and they had different worksheet IDs, if all of them are in fact in part of the same sentencing event, you're ultimately going to need to combine all of the case information under one worksheet ID. So you just pick one and make sure that you're combining all of the unique case information. So in this case, if I say, oh yes, it is being sentenced with these other two case numbers, I'm going to click select. And then it's going to give you confirmation that you're now editing that already existing worksheet ID number, and you would click OK. Now, generally, if a worksheet ID has already been saved in MAGS, at that point, if you're seeing a case number, offender information, offender score, and list of offenses has probably already been completed. So if I were to jump here, I can clearly see those other two case numbers. They're meant as two different criminal events. And then if my case number occurred on a different date, it obviously has its own unique case number. When I went to add offense here, I could just simply note criminal event number 3 and then continue on entering that unique case number information. I'm not going to do that now because I'm going to go from scratch to show you how a multiple criminal event, single sentencing event scenario should be initiated. But that's how you would get through that alert message. And again, it's very important that these multiple criminal events, single sentencing event scenarios are initiated properly. Okay, so those are two relatively newer features. So now we're back to the drawing board and we're just creating a multiple criminal event, single sentencing event scenario from scratch. So I'm going to go ahead and click add new, and then I know we've been to offender information a couple of times at this point, so I'm going to fly through this one and then we are moving forward here. I'll go ahead and select that SID number here. Oops. Go ahead and say Kent here with private representation. And then we're going to go ahead and save this page. All right, so also as we're seeing up here, MAGS is divided into several tabs, each of which represents a different section of the worksheet. So you all are generally responsible for completing offender information, offender score, list of offenses, and then most of victim information here. And you can toggle between the tabs by either clicking the next button here, or you can click on the header here. All right, so moving on to offender score. Now, part A that we talked about earlier, relationship to criminal justice system when the instant offense occurred, that can vary between offenses, especially if you have multiple criminal events that are a part of the same sentencing event. So we're going to score that once we get to the list of offenses tab. But here's where I would make my selections for juvenile delinquency, prior adult criminal record and prior adult parole probation violations. So just to note, if you did have to apply the decay factor, you would simply mark what the initial calculation of the record is, and then you would click yes under the applied decay factor radio button. And you can see once I do that, it jumps down to a moderate. And then when you're actually viewing the worksheet, you can see in red text that it's because of the decay factor. And then no prior adult parole and probation violations. So then I'm clicking save this page. Moving on to list of offenses. So again, I know I sound like a broken record, but this is the tab where you're entering, especially if you have multiple criminal events, all of that unique case number information. You're not creating a new worksheet for each separate criminal event if they're a part of the same sentencing event. So let's begin with adding offense number 1. So this is going to be a part of criminal event number 1. And then you just want to list the count number as it's listed in the indictment. So this is going to be count number 1. And the offense date's going to be 2/12/2026. And then you would just proceed with entering the remaining case number. You can see it pre-populates based on the jurisdiction that you select on the offender information tab. And then moving on to offense title. Now, 2 different ways you can search for offenses, either most common offenses, which if you click that, it brings you to our most common guidelines eligible offenses, or you can just search our general offense table by clicking search for all offenses. Now, you can further narrow it down by searching for specific terms in an offense title, CJIS code, statute, or type. Now, I will say regarding statute, several of our offense entries contain penalty portions of the statute. So I get a lot of questions about that because people are kind of comparing what they see on a statement of charges, which has, the offense description subsection of a statute. And when they're trying to match it to MAGS or search for it by that specific statute, they're not finding it. And it's because generally our offense table contains the penalty portion of a statute. So I always suggest if you want to search by statute, it's best to do so generally. So for example, if I was trying to find a distribution of a cocaine, just searching by the penalty 5-608, you can see that brings me right to what I'm looking for here. So if you ever get caught up searching by statutes, maybe search more generally. Also, searching by specific CJIS codes is a great way to go. Now, you can also simultaneously search all of these columns in the upper left-hand corner in the search button. So for example, if I just wanted to look for, I'm looking for an assault first degree, as soon as I type in the word assault, all of the offenses that contain that word are going to populate here. And then I have my assault first degree, and then I select it there. Now, any attempt, conspiracy, or solicitation, you're normally just going to be marking that as a radio button. But just to quickly show you, if you did have an offense, one of the more serious ones that involved an attempt conspiracy, you can see here from the offense table, that's where you would want to make the attempt conspiracy solicitation selection because they are listed separately. Now, any additional enhancement, for example, if the defendant is being charged with a subsequent drug offense or a subsequent crime of violence or repeat sex offender and therefore subject to an additional enhancement, you could apply that enhancement here. And if you want to flag an offense for the multiple victim stacking rule. So in this particular case, I'm going to go ahead and mark yes, because I'm going to enter an additional assault first degree that involves a second victim. So I'm going to say okay, and then it's going to prompt you to select which victim number does this apply to. So this is going to be for victim number 1. So jumping down, now you make your selection for relationship to criminal justice system when the incident offense occurred. Everything else pre-populates regarding the offender score based on selections you already made. Now this is a person offense, so I am going to make selections for the offense score. MAGS will automatically calculate Part A just based on the seriousness category of the offense. And then you go ahead and make selections for victim injury, weapon presence, and special victim vulnerability. Also to note, these information icons throughout MAGS, if you click on them, they give you more detailed explanations of what we're looking for, and all of the language is taken directly from our manual. So definitely encourage you to check those out if you have a question. And then finally, I'm going to click Calculate Guidelines Range, where I get the individual guidelines range calculated for the offense, as well as the overall guidelines range for the sentencing event here. So then I'm clicking Save this page and close. And there I have my first offense. Okay, so now that we have that down, I'm going to quickly go through a couple more offenses here because I know we only have a couple more minutes. So now I mentioned I'm going to add an additional second degree or first degree assault rather that involves a second victim. So this is still going to be a part of that same criminal event number. So it's going to be criminal event number 1, but this is going to be count 2. So it's going to have the same offense date that I just entered and the same case number. And I know if I just click on most common offenses, that's actually the first offense that I see here. So I click select, and then I want to flag this for the stacking rule because it involves a second victim. So this is going to be victim number 2. And then jumping down to make my selection for part A of the offender score and the remaining selections for offense score. So again, this is going to be an injury, non-permanent, weapon other than a firearm. We'll say this was special victim vulnerability because the victim happened to be older. Okay, so here I'm going to click calculate guidelines range. And again, we can just see how the overall guidelines range is updated as you add offenses. Save this page and close. Okay, so next I'm just going to add a second criminal event. When it's going to have a different case number, different offense date. So I would proceed by entering add offense here, and I want to make sure I'm noting this as criminal event number 2. You want to make sure when you have multiple criminal events that you're properly noting the event number, because that's how MAGS knows to add the ranges together if there are multiple criminal events. So this is going to be criminal event number 2, count 1. So it's going to have a different offense date than the one I just entered, and a different case number. And here I'm looking for a distribution of heroin. So I quickly found it by typing the word heroin. And jumping down, so again, making my selection for part A. Now this is a drug-related offense, so it doesn't involve or doesn't require an offense score, so that's going to be disabled. So I just simply jump down and click calculate guidelines range, save this page, and close. Okay, so now I have my criminal event number 2. I'm going to add one more offense to criminal event number 2, and then we're going to wrap up here. So this is still going to be criminal event number 2. This is going to be count 4 within that criminal event. So same offense date as the one I just entered, as well as the same case number. Now I'm going to click search for all offenses. I'm looking for a particular offense here. So here I'm looking for the knowingly violated criminal law 5-602 with a mixture of heroin and fentanyl. So I'm going to go ahead and click select here. Again, just jumping down, making my selection for part A. This is also a drug offense, so I'm just going to jump down and ultimately click calculate guidelines range. So you can see once I do that, I get this little drop down that says mandatory consecutive sentence, and it's prompting me to select an offense for this to run consecutive to. So I'm going to click on this alert message here. Now, this message says to obtain the upper limit for the overall guidelines range for a criminal event with multiple offenses, and if the sentence for one of the offenses is statutorily required to run consecutive to the sentence for another offense in the same criminal event, the person completing the guidelines worksheet shall add the upper limits of the guidelines ranges for the 2 eligible offenses whose sentences are required to run consecutive to one another. So I know that's a mouthful. But essentially, when you're calculating guidelines and one of the offenses that you select is statutorily required to run consecutive to another eligible offense in the same criminal event, you're going to be prompted to link those 2 offenses because by guidelines rule, those upper limits should be added together. So statutorily, the sentence for the knowingly violating criminal law 5-602 should run consecutive to another eligible offense in the same criminal event. Now, let's just say maybe you see that message, maybe you somehow missed it and clicked save this page and close out. So MAGS will once again, if you happen to miss it on the list of offenses tab, it gives you another alert message here saying, please address the offenses that have warnings. And I can see once I look next to this offense, it gives me a little alert message. If I were to click it, it's telling me the mandatory consecutive offense is missing. You click OK and it brings you back. And then if I were to click this drop down, MAGS will give you all of the other eligible offense within the same criminal event as the offense that has the mandatory consecutive sentence. So in this case, I'm going to link it to the heroin, go down, click calculate guidelines range one more time, and then those upper limits would be added together. And then I'm clicking save this page and close. Okay, I know we're running short on time, but I have one more tab here. So moving on to victim information. So we do ask that you all complete as many fields as you can related to the victim information field prior to sentencing. That said, there are some fields that can't be completed until after sentencing. So for example, whether the victim was present, if they gave a written or oral victim impact statement, that can be completed by the judge or judge's designee post-sentencing. So here I'm just going to state that yes, there was a victim. And again, you can utilize these icons. I'm not going to go through every single question here just for the sake of time. But let me go ahead and make my selections here. And then, okay, clicking save this page. All right, so at that point in time, I have everything initiated that needs to be initiated prior to sentencing. And to view your final PDF, you click View Worksheet PDF. And I can see when looking at the worksheet here, it has the multiple victim stacking rule clearly noted for the assaults. And then on the second page here, I have my drug-related offenses because by guidelines rule, each separate criminal event should correspond to their own worksheet. Okay, so that concludes the MAGS demonstration. Does anyone have any questions? Did anyone want me to review anything in MAGS before we just wrap up with our last slide here? Okay. Okay, let me go ahead and just pull up the last slide. Bear with me 1 second, and then we will conclude for today. 1 second here. I need do. Sorry, bear with me 1 second. Do. Okay. So I just wanted to give you our contact information. If you all ever have questions, feedback, just about the guidelines in general, maybe you're having trouble navigating through MAGS in a particular case, you can always feel free to contact us. Our general emails, msccsp@umd.edu, main phone number 301-403-4165. If you've contacted us before, you know I'm the first point of contact usually for the commission, and I'm always happy to help. I do just want to wrap up by noting several resources we have available on our website, such as our annual reports. If you don't currently subscribe to our guidelines at eNews, please shoot us an email and I will make sure to add you to our listserv just so you can stay informed of recent guidelines changes. We have reports on guidelines compliant, average sentences, sentencing snapshots, various instructional videos, and then also our crimes of violence data dashboard. So feel free to check out those resources on our website. Sarah, I'll just check in with you real quick. Is there anything to address? I don't see anything in the chat box.
No, we don't have anything outstanding. Thank you.
Okay, great. All right, thank you all so much for attending on this Friday afternoon. I hope you found it informative and learned something, and we look forward to seeing you at a future training. And with that, have a great rest of your Friday and a wonderful weekend. Thank you.